a proposal that this debate continues until 8:30 p.m. So I'm just giving you forewarning of that. Deputy Kearns.
Thank you, Laskin Corla. The amendments from Deputy Batchik seek to address one of the most significant barriers in the bill, the mandatory information session. The committee's pre-legislative scrutiny report was unambiguous in recommending that the mandatory information session should be removed from the legislation. An alternative appropriate safeguard should instead be provided for, such as the sending of correspondence by registered post. The Irish Human Rights and Equality Commission stated that the information session presented an obstacle and potentially a complete barrier to individuals accessing long-sought information. The Council of Irish Adoption Agency described it as contradictory to the spirit of the bill. Others classified it as insulting, discriminatory and restrictive. That it is still in the bill in its current form is deeply concerning, ignoring both the wishes of people affected and of human rights experts. If we accept the Minister's argument that some mechanism is necessary to address the balancing of rights of accessing information and privacy, then the registered post option should be pursued rather than the paternalistic and insulting requirement for an adopted person having to sit down with a state agent who explains to them what they already know. Adopted people are already very knowledgeable about access to information and privacy. They have been forced to be by this government and previous governments. Also, the Minister's position fails to acknowledge that secrecy was imposed by the state, by agencies and religious orders on both adopted people and parents. There was a systematic and highly organised process to arrange illegal adoptions, to falsify records and to cover up the whole thing. The refusal to allow people access their personal information was always about this system protecting itself. Unfortunately, the ongoing restrictions for GDPR and most conservative interpretations by state bodies continues. If the Minister insists on retaining this barrier, then in line with the Children's Committee discussions, Deputy Batchik's amendment ensures it is at least non-invasive and considered.
Minister.
Thanks very much, Laskin Corla. Fundamentally, what the information session is about the balancing of two sets of fundamental rights. The fundamental right to information, identity information of adopted people, that right that we all know has been denied for so long, and the fundamental right to privacy of a parent. The information session will apply in a very small number of circumstances because it will only apply where a parent has proactively gone and decided on the contact preference register to clearly register a no contact preference. We've discussed before, there's an existing national contact preference register. We've discussed before the very small number of parents who've done that. It's in double figures. But it is still, by that small number of people, it is a clearly demonstrated expression of their wish to exercise a right to privacy, a right to anonymity. And Deputy Kearns spoke with great elegance about the system of secrecy that was developed here. And you're right in all that you say, but it is not for me, it is not for any of us, if a parent wishes to register a no contact preference. I don't believe it's for us to question that. I don't believe it's for us to dispute their desire. So the question, perhaps we do dispute that. I don't dispute that anyway. If they, for whatever reason, believe that they need some barrier to contact, if that's their view, I don't think it's for the Oireachtas to dispute that. So the question then is, how do we balance their desire to exercise their fundamental right to privacy with that desire for information? And we have established in this legislation a system, a process whereby in every situation the adopted person will get their full right of access to information. In every situation following this process, full information will be provided. And, you know, I think sometimes we forget what a sea change that is, the scale of the change that this legislation is bringing out compared to the situation now, where the assumption, the working assumption is restrict, don't release, keep the information hidden. And the reason for that was for constitutional reasons, because of the court case from the late 1990s that, and I know there's disputes about its interpretation, but that court case decided by the Supreme Court has had that restrictive effect. And that court case shows that there are individuals who will go all the way to the Supreme Court because of their concern about their privacy rights. And I don't question that judgment call, but it does demonstrate, and it is why so many of the attempts to legislate in this area have floundered, because the worry about the constitutional balancing test here. And in engaging with the Attorney General, and particularly since the introduction of GDPR and that much stronger recognition within EU law of privacy rights, we've been able to find a mechanism which seeks to balance those two sets of rights. And it is a mechanism that we didn't invent ourselves. It was a mechanism that has been brought forward before, that has been proposed by academics, that has been proposed by advocacy groups in previous draft legislation. And I suppose that's why, people can disagree with it, but when it is seen, it is described as insulting or degrading to people, I just make that point again, that this mechanism has been used, has been proposed for use as a balancing of that incredibly difficult set of rights that are so fundamental to different individuals. And we have changed how we set about this balancing, because it's been said nothing has been done here. We brought forward a significant amendment at committee stage, recognising that some of the language in terms of the explanation of privacy rights, that was the language used in the original draft, recognising that no, that's not okay. We shouldn't be talking about that. So now the information session, used in that very small number of situations, is purely a factual process. The parent concerned, the relevant person, the adopted person, the person subject to an illegal birth registration, is told that their parent has exercised their entitlement under Section 3811 to state that he or she is not willing to be contacted by the relevant person, and the making of that statement by the parent constitutes an exercise by him or her of their right to privacy. And at that point, after that has been conveyed, the full information is then released. And we believe, from the point of view of ensuring that this legislation is constitutionally sound and is constitutionally protected, and I strongly believe that at some point this legislation will be challenged. I think there is a very high likelihood that that will take place. And look, it's legitimate for someone to do that. But having waited 20 years for this legislation, having seen 4, 5, 6 attempts of drafts of legislation not get through this House because of an inability to resolve this, I don't want a situation where a piece of legislation where all of us in this House have worked very hard to try and get those definitions broad, to get those processes working well. I don't want to see that legislation at risk of constitutional challenge. And we went into the issue of the proposal in terms of a registered letter, and notwithstanding, the worries about will the information, and even if someone signs to say they received it, whether it's read, whether that actual point has been conveyed, it has been the call was that the method set out here is the greatest restriction of the privacy rights of parents that we're prepared to bring forward, that we believe will be constitutionally valid. And we have a duty to ensure that this legislation is valid, so that the huge amount of rights and that right to full release of information that it provides can be delivered to adopted people.
Cian Corla, and Minister, firstly, I think just your insinuation there that I dispute parents being able to register a no-contact preference is ridiculous, and I think that's evident in the fact that we're not debating amendments to remove the no-contact preference. We're debating amendments on removing a mandatory information session for adopted people, and I think that you're bringing that into it is just evident of the non-existence of legitimate argument in keeping a mandatory information session. If we accept your argument that some mechanism is necessary to address the balancing of rights of accessing information and privacy, then the registered post option should be pursued rather than the paternalistic and, like I said, insulting requirement for an adopted person to have to sit down with a state agent who explains to them what they already know. Like I said earlier, adopted people are already very knowledgeable about access to information and privacy. They have been forced to be knowledgeable about this by this government and previous governments. They don't need a mandatory information session.
Information and Tracing Bill report stage. Amendment number 59 in the name of Deputy Ivana Bacik. The question is that the amendment be made, and on that question a division has been challenged. Tellers Thaw, Deputy Ivana Bacik and Deputy Kathleen Funchion, Neil, Minister Jack Chambers and Deputy Brendan Griffin. 59, Neil 71. There were no abstentions. The question is defeated and Amendment 59 is lost.
I don't want to repeat other deputies, but to welcome some of the changes that you've made to the legislation and for all the work that you and your department have done on it, and really just check if is there any chance of that last change in relation to the mandatory information session. You know, if we accept your argument that it has to be there, then I think a really good compromise is that the way it can be carried out could be achieved through Deputy Bacik's amendment, and I think there'd be a lot more support for the bill if that was just potentially reconsidered, like Deputy Bacik said, maybe at Shannon stage. Thank you.